Hello there and welcome to our brand new show, The Role of Law, where our intention is to bring to you the law in a simplified manner so that you can understand what the law really is and what are the rules and regulation that really govern you here in Sri Lanka. Of course, the time or the current situation in Sri Lanka has laid out the topic of discussion that we need to take up for the first show, and it's a matter that is of constitutional importance. The 19th Amendment to the Constitution, the proposed 20th Amendment to the Constitution, and the entire constitutional overhaul that has been proposed by the government. And we are happy to take up this matter for discussion because it is a matter that affects every citizen of this country. And to discuss these, we've got with us today attorney at law Suren Fernando. He appeared in the constitutional cases that preceded, of course, this show. Thank you very much, sir, for taking time off your busy schedule and attending this show.
Thank you for having me, Sharon. Pleasure to be here.
And before we really get into our discussion, let's take a look at a few of the provisions in the 19th Amendment to the Constitution that we will be discussing on the first segment of this show.
The 19th Amendment to the Constitution was passed in Parliament on the 28th of April 2016 with a majority of 2/3. 212 members voted in favour, 1 voted against, 1 abstained and 10 MPs were absent. The amendment introduced substantial changes to the executive presidency and the legislature, strengthened the Constitutional Council and independent commissions, and introduced the right to information. Changes to the executive presidency reduced the term of president from 6 years to 5. Reintroduced the 2-term limit on the number of terms a person can hold office as president. A person who is below the age of 35 or a dual citizen is disqualified from being elected to the office of president. Dual citizens are also disqualified from being elected as members of parliament.
So, well, that included 3 specific provisions. What's your take on the reduction in the term of the presidency?
So you see, Sharon, I think these have to be looked at holistically.
Okay.
And you've had over a long period of time, since at least 1994, in every major national election, one of the topics for discussion was reducing the powers of this overmighty executive or abolishing the presidency altogether. Now, the promise during the 100-day program was to do what you could do without a referendum as a first step. Now, the 18th Amendment took away the term limits which the original 1978 Constitution had. Now, term limits are necessary because you have this incumbency bias, and if you also running in a system which is not absolutely free and fair, and I think we would agree that definitely the system we had before, there was a politicization in much of the system. There was election related corruption, misuse of state resources. In that type of a system, you absolutely need term limits so that you can, at least after a particular period, reset, and then people have the right to choose, right? So that was the term limits part. And with that, you look at the term as well. So there was a feeling that 6 years was too much. There was much discussion. And I think President Maithripala Sirisena was also on record saying that he suggested making it 4. So there was a broad discussion, and there was an agreement that 5 was a reasonable period. So that's how you had those two coming together.
Right. Also, let's speak a bit about another problematic provision in the 19th, at least right now. They've proposed to repeal this, and that is the disqualification of dual citizens from holding the office of president and parliamentary seats.
Now, I don't know to whom it's a problematic provision. It's certainly not a problematic provision to me. You have this concept of divided loyalties. You are a citizen of country A and a citizen of country B. And if you are going to serve the legislature or the executive in country B in its highest ranks, and there is a conflict, a situation which, the decision you need to take, there's a conflict of interest with the interests of country A. which side are you going to be on? You have one leg on both sides. So the idea of introducing that provision was to ensure that people who come into our parliament, people who assume office as the executive president, are not people who have divided loyalties to more than one state.
But according to Professor G.L. Pires, he was caught on record saying that these provisions were not passed bona fide. They were targeted at certain individuals, and I'm pretty sure you know who I'm referring to.
Well, I don't agree. I don't think there was any evidence to suggest that that was the reason for introducing these provisions. But the 19th Amendment Bill was gazetted somewhere in March, mid-March 2015. There was a lot of debate in committees, unofficial committees in Parliament, between the political parties, before it finally was taken up for debate at the end of April 2015, and that is after it went to court as well, after it went to the Supreme Court. So there was a long period of time when all these people could have discussed this, and to my mind, to my memory, I don't think any of them raised this issue as a problematic area. So it was in the original 19th Amendment Bill, as well as in the 19th Amendment which was passed. It was not something which was smuggled in at committee stage or something like that. Now, Professor G.L. Pires, since you mentioned him, I believe, was also part of the Parliament who voted in favor of this provision. None of them said that, this is targeted at anybody, it's not desirable. In our country, it's okay to have people who have divided loyalties, so let's remove this provision. And if they had in fact said that, they would have been able to ensure that it was removed at committee stage, because now you had other provisions. For example, one which strengthened the, we have a problem with crossovers. So there was a provision in the 19th Amendment Bill which sought to prevent people under disciplinary action from trying to get enjoining orders, etc. And after disciplinary action is taken, they could have canvassed it only in the Supreme Court.
Amended.
That was removed at committee stage. So that is because the government of the day was a minority government. It relied on the UPFA majority to pass this bill. So if these provisions are problematic, why didn't they raise it? Why didn't they say, no, we won't vote for this unless you remove this also? So they never saw it as a problem or as anything political. This is, I think, an afterthought.
Mr. Fernando, just a quick answer to this question. Is there a requirement that constitutional amendments need be bona fide?
Well, it doesn't say so in the Constitution, but I think they should be bona fide, because you draft a constitution or a constitutional amendment for all time. It's not meant to serve just.
That's definitely not been the case in Sri Lanka.
Yes, unfortunately. But two of what I consider the two of the best amendments, the 17th and 19th, I think, have been done in a bona fide manner.
We'll continue this conversation after taking a look at a few more amendments that were introduced to the Constitution through the 19th Amendment.
Under the 19th Amendment, the President no longer has the power to remove the Prime Minister at his discretion. The President is required to act on the advice of the Prime Minister when appointing or removing from office any Cabinet Minister, non-Cabinet Minister or Deputy Minister. The amendment introduced a ceiling on the number of ministers, both Cabinet and non-Cabinet. The total number of Cabinet Ministers was limited to 30. The number of non-Cabinet Ministers and Deputy Ministers was limited to 40. However, it also allowed Parliament to determine on its own accord the number of Cabinet Ministers and the total number of non-Cabinet Ministers and Deputy Ministers where a national government is formed. Prior to the 19th Amendment, the President could assign to himself any subject or function not assigned to any other Cabinet Minister. This provision was repealed by the 19th Amendment.
Now, these balancing of powers between the President and the Prime Minister, of course, at the time these amendments were passed, because we need to look at these amendments in context, there was a President from a separate party, Prime Minister from another party, there was a turbulent situation in Parliament at least. Are these really the best amendments for Sri Lanka?
Right. So again, I think you need to look at this in a holistic way. Now, the original 78 Constitution said that the President must be responsible, answerable to Parliament. Now, how is that
possible?
Ensured. That is ensured by the Parliament being able to question certain things the president done, and also by financial allocations. But has that ever happened in practice? And if not, why? The reason why it couldn't happen is because under the original 78 constitution, the president could decide on who the ministers are going to be. Allocate to himself what he wants, allocate to whoever else he wants what he wants. So basically, you dangle the carrot before the people who are supposed to be supervising you.
Right.
So how are they going to exercise a check on you?
So,
Now
but these
if
are
you-
only the ministers of parliament and not the, ministers of the government.
Deputy minister, no, not the members of parliament, the ministers.
ministers.
So ministers are drawn from parliament. So you appoint X number of ministers, X number of deputy ministers, X
Of course,
number of
you'll have control
non-cabinet
over the
ministers,
majority.
and you have control over the majority, which is what has happened in our history, unfortunately.
And also
Because
one of the reasons behind us going into the Guinness Book of World Records for having the biggest cabinet
Perhaps.
in the world.
So, and sometimes you might, the reason for having such large cabinets might have been to ensure that you keep a lot of them friendly, right? So it's in that context that the 19th Amendment was also trying, in the interim period of having a new constitution at least, the 19th Amendment sought to move towards a parliamentary democracy, move towards that. Now, in a parliamentary democracy, the Prime Minister is required day in and day out to be to hold the confidence of Parliament. Now, if you want to sack a president, to impeach a president, it's a very cumbersome process. It has never been done, right? You've never had a president impeached. The Prime Minister, you can throw him out by a simple no confidence motion against the government. So that ensures, I think, a check on this power. Also, because you're moving towards a parliamentary system, it was necessary to then say, okay, the ministers will be drawn from parliament only. So that other provision which said the president can hold certain ministries was removed, subject to a transitional provision which applied to the then incumbent president, which allowed him only during his period of office to hold the portfolios of defense, Mahawali and environment.
But now, since you spoke about the allocation of ministries to the president, it's quite interesting that the current president also holds the Ministry of Defense. And under the Ministry of Defense, the institution of public administrations have also been assigned under the Ministry of Defense. So the president exercises quite a sizable power over ministries and in the cabinet per se, although the constitution says that the president cannot hold a ministerial portfolio. And we discussed this matter with the Minister of Justice himself, President's Counsel Ali Sabri, on our program Newsline with Farah Shaukat Ali, and this is what he had to say.
In terms of Article 4 of the Constitution, he should be the commander of all the forces and in charge of the defense of the country. So there is this haphazardly brought up 19th Amendment, which says that the president cannot hold ministries. So there is an obvious conflict. Article 4 is far superior to any of the other articles which have been brought by amendment. So therefore, it clearly, president has the power and the mandate to hold defense portfolio. So
I wouldn't agree. Now, in the first place, the fact that the president is the commander-in-chief is referred to in Article 30. What Article 4 refers to is the fact that executive power, including the defense of Sri Lanka, is vested in the president. Now, that is the reason why in the president's powers, the enumeration of the president's powers, the president is given the power to declare war and peace. And his power to declare war and peace, unlike the other powers which can be questioned before the Supreme Court, is not subject to question in the Supreme Court. So even though the 19th Amendment reduced the president's immunity and allowed his decisions to be subject to review by the Supreme Court, that power is not subject to review. So you have the military, but formally the control of the military is vested in a civilian authority, the president. He is the commander-in-chief, and that is what is meant by the defense of Sri Lanka, not that you have to have a ministry. Now, even in the past, if I am not mistaken, during the tenure of Her Excellency Chandrika Kumaratunga, she could have held the defense ministry, but she chose to vest it with someone else. So it is not essential that the president be the person who is vested with the portfolio of defense. with regard to the present situation, the Gazette declaring the allocation of appointment of ministers rather, to my recollection, you may correct me if I am wrong, does not refer to the fact that it has been allocated to the President. So I believe the omission to refer to the President as the Minister of Defence is because the government knew that you cannot allocate that ministry to the President. Because if by default defence was going to be something which was allocated to the President, there was no need for the 19th Amendment to have a transitional provision which said that only for the President who was then in office that he could hold this portfolio. That alone shows that no portfolio can be held by the President, but only for that President those three portfolios were allowed.
Just for argument's sake, if President's Counsel Ali Sabri said there is a contradiction between this provision in the 19th Amendment that limits the President's ability to hold a ministerial portfolio and a pre-existing provision in the Constitution, which would prevail?
Well, in the first place, I don't agree that there is a conflict. In the second place, a similar situation arose during the coup or the unlawful government situation in 2018 and the dissolution, where those who said the dissolution was lawful sought to argue that the President had been given in one article the power to dissolve Parliament. In another article, the power was exercise was spelled out, the manner of exercise was spelled out, and it said within the first 4.5 years you can only do it if Parliament asks you. In the balance 6 months you can do it. So then they also said this conflicting position was there. And the court said when there is a manner specifically spelled out, it means that the power you have and you look, basically I'm paraphrasing what the court said, you have the power but the manner of exercise is spelled out. So here also, yes, you have executive power but the manner of exercising it is spelled out. So you can declare war and peace, you can be the head of the cabinet which formulates national policy, etc., etc. But that is spelled out, but ministries is specifically excluded because it says specifically that ministers must be drawn from Parliament, and the earlier provision which allowed a President to retain a ministry is no more. That makes it pretty clear to me.
Well, also another area of the 19th Amendment that has drawn criticism and praise is the Constitutional Council. Let's see what the 19th Amendment says about that.
The 19th Amendment to the Constitution strengthened the Constitutional Council. The Constitutional Council consists of 7 members of Parliament and 3 eminent persons. The 3 persons appointed to the Constitutional Council should be people of eminence and integrity who have distinguished themselves in public or professional life and who are not members of any political party. They are to be nominated together by the Prime Minister and the Leader of the Opposition. The nominations made by the Prime Minister and the Leader of the Opposition are required to be approved by Parliament. The 19th Amendment made provisions for the Constitutional Council to approve the nominees of the President for the office of Chief Justice, judges of the Supreme Court, President and judges of the Court of Appeal, members of the Judicial Services Commission, the Attorney General, the Auditor General, the Inspector General of Police, the Ombudsman and the Secretary General of Parliament.
Now, the Constitutional Council is not something new to Sri Lanka. It was introduced through the 17th Amendment, done away with the 18th Amendment, brought back through the 19th. Any reasons you can justify going back to no Constitutional Council?
None at all, certainly not in a country like Sri Lanka. The interesting thing is the 17th Amendment was passed by an overwhelming majority of Parliament. Some of the people
it was a bipartisan bill that was passed.
Some of the people who now criticize the Constitutional Council voted in favor of the 17th Amendment as well.
And the 19th.
And the 19th. Now we have the experience of that 17th Amendment, Constitutional Council.
Right.
That was built on in the 19th Amendment. Again, as I said, this was not a one-party show, the 19th Amendment. It was introduced by a minority government. People made sweeping changes to what was in the draft at the committee stage. For example, the original version envisaged 7 politicians, if I put it like that, and 3 from Parliament, like the 17th Amendment Constitutional Council.
So to reduce political influence in the Constitutional Council and appointment to high posts in Sri Lanka.
Yes. But that balance was swung the other way around in committee stage. There were various other changes also made. So now those same people who had this experience since 2001, 2002 of how Constitutional Council works, who contributed to the discussion on the Constitutional Council in the 19th Amendment, I fail to see any basis for them now, when they are in government particularly, to have developed an aversion to this mechanism.
Speaking specifically about the composition of the Constitutional Council, you said it was initially envisaged to have 7 civil society members and 3 parliamentarians. The numbers were flipped around. But there has been a lot of criticism regarding these 3 members who have been appointed to the Constitutional Council. Let's hear a few that were uttered by Professor G.L. Pires very recently, I believe, 24th of this month.
ජනාධිපතිවරයා වෙනස් වුණා. ආණ්ඩුව වෙනස් වුණා. අගමැති වෙනස් වුණා. පාර්ලිමේන්තුව වෙනස් වුණා. හැබැයි මේ සිවිල් සමාජය කියන දේ නියෝජනය කරන ව්‍යවස්ථා සභාවේ ඉන්න 3 දෙනා තව අවුරුද්දක් ඒ තනතුරු වල එහෙමම ඉන්නවා. හොලවන්න බෑ. ඒකද ප්‍රජාතන්ත්‍රවාදී. මේකද දිවි හිමියන් රකින්නයි කියලා අපිට කියන්නේ.
Is this democracy?
It is exactly democracy, because the idea is that certain appointments, they are not meant to fluctuate just because governments come and go. If that happens, that means those who hold those offices are also subject to the political winds. But some of those things should be stable. I mean, is an extension of this type of argument going to be that every time the governments change, we should change the judiciary also? I mean, that's the absurd limit to which this type of argument can be pushed. The fact that those people remain for a fixed term of office means that they are guaranteed independence by the tenure being guaranteed. So that independence is guaranteed. If they have to depend on the goodwill of a new government and a new opposition to continue in office, that would compromise their independence.
And their ability to exercise their discretion in matters concerning the entire country. There is also another section of the 19th Amendment that is intertwined with the Constitutional Council, and that has drawn similar praise as well as criticism. And those are the Independent Commission. Let's have a look at these provisions as well.
The 19th Amendment also established independent commissions. Members of the Public Services Commission, National Police Commission, the Human Rights Commission, Commission to Investigate Allegations of Bribery and Corruption, Finance Commission, Delimitation Commission, National Procurement Commission, and the Audit Commission can be appointed by the President only on the recommendation of the Constitutional Council. The Elections Commission has the power to prevent the political party in government from using state resources, including state broadcasters, for their election campaign. Article 41B, subsection 6, provides that all the commissions referred to in the schedule to the article, other than the Elections Commission, shall be responsible and answerable to Parliament. However, in terms of Article 104B, subsection 3, the Elections Commission has specifically been made responsible and answerable to Parliament.
Well, the arguments put forward by the government justifying the removal or the repeal of these independent commissions are quite similar to the ones for the repeal of the Constitutional Council. They say that these are really not independent. Is there independence in these? And the appointments, how democratic are they? How far can you stretch these arguments?
Well, you see, let's look at the situation which would prevail if you didn't have a Constitutional Council. Then all these institutions, the higher judiciary, the appointments would be made by one person. I think given the experience we have had with commissions in the past, appointments by one person, we can all agree, is something which is not desirable. Because then you would appoint someone, there is the possibility that you would appoint someone who would take a line which you want. And the object of a constitution is, one of the objects, is to ensure that there is a check on power and that the potential for abuse of power is reduced. Now let's look at the Constitutional Council appointments to commissions. Now you've had, let's take the Election Commission. We've had what has been said to be the two most peaceful elections in our history, run by an independent election commission. They've run it with necessary health regulations, etc. You've had the establishment of the Audit Services Commission and the appointment of an Auditor General through the 19th Amendment process. It was that same Auditor General who assisted Parliament in investigations into the bond scam. You've had a Human Rights Commission which has been internationally acclaimed as one of the best commissions in the world. Now, some political actors, members of civil society might disagree with the conduct of particular individuals in these commissions. All that the law can do is create a mechanism which facilitates the appointment facilitates a mechanism which ensures independence in appointments. Thereafter, it's up to that process to ensure that suitable people are appointed. Even if you appoint suitable people, sometimes once they're appointed, they become unsuitable. I mean, you've seen this in other fora as well. Now, recently you had this talk that this Desiya Visipahama Epa, we don't want any of these people in Parliament. Now, the mere fact that you have some people who you or I might consider undesirable in Parliament
doesn't mean that
the institution should be thrown out. Now, after people said, all these types of people are there, in the recent elections also, some of those types of people are returned to Parliament. But that is not an argument to say get rid of Parliament. So, you have a good process by which people can choose suitable individuals. Whether people choose suitable individuals is another question. Similarly, you have a mechanism which can ensure some degree at least of independence. But thereafter, you have to choose people who will ensure that they function with that type of independence.
So all that the law can do is really reduce the room for abuse.
Reduce the room for abuse and create a system, a structure where suitable people can be appointed. Merely because you have one person here, one person there who you think is not suitable is not a reason to scrap the whole thing. Because the position which would be there if you don't have this is far, far worse.
But then the criticism against it is quite damning. Let's take a listen to what Professor G.L. Pierce had to say.
මේක NGO නඩය නොයෙක් බලවේග එකාසු වෙලා ගොතපු බොරුවක්. එම නිසා මේ විවාදය දැන් මේ විවාදය රට පුරා කෙරෙන්නේ එන සති කිහිපය තුළ විවාදය පටන් ගන්නේ මේ ස්වාධීන කොමිෂන් සභා පට්ටපල් බොරුවක් කියලා මම කිසිසේත් පිළිගන්නේ මේ එක කොමිෂමක්වත් ස්වාධීනයි. ඒවා ඔක්කොම හැදුවේ රාජපක්ෂලාව හිරේ දාන්න.
Well, there's one part that you can't disagree with him on that. He said the debate will take place in the coming weeks, and that's exactly what's happening right now. But let's discuss on the content of that statement. He said that these independent commissions were drafted by NGOs. It's a collaboration, a conspiracy by them. Is that true?
No, the 19th Amendment was drafted by a committee of individuals. This was not a NGO-foisted bill in by any stretch of the imagination, but of course the views of civil society were taken into consideration. There was a large demand for creating independence in the executive, right? So those views were certainly considered, and the National Movement for the Venerable Sobhita Thero's movement was also pushing for these types of amendments. Now again, with all due respect to the professor, he voted in favor of the 17th Amendment.
But let's just not hold that against him.
So he had that experience.
Okay.
Now, if he thought that this was intended to victimize the Rajapaksas, why did he vote in favor of the 19th Amendment as well? In fact, if I am not mistaken, in January 2015, he authored an article in the newspaper where he made proposals to how, the University Grants Commission and something else should
fall under these independent
should
commissions.
also be subject to the Constitutional Council, etc., etc. So That's
Can't
why
a
I
man
said
have a change of heart?
you can have a change of heart, but I think it's a bit of a stretch of the imagination to say that these were all intended to target particular people. I mean, audit, Human Rights Commission, Police Commission, etc. So many commissions. Which ones, what was targeting who? I mean, apart from the bribery commission, and I don't think that they have
Done their job, if that's the
taken,
case.
taken filed any indictments against perhaps one or two, I'm not aware, but there are so many others. And again,
So really doing away,
UTFA supported bill.
doing away with these commissions, lock, stock and barrel, is really not the best course of action.
Certainly not, and there is no allegation with regard to the independence of the bribery commission, for example, led by two very respected former judges and another high-ranking public official.
Well, we're in the final few minutes of our show. We really can discuss only one more set of provisions in the 19th Amendment. Let's have a look at that as well.
The 19th Amendment removes the President's power to dissolve Parliament at his own discretion. According to the amendment, the President can dissolve Parliament only if two-thirds of the members of Parliament pass a resolution requesting him to dissolve Parliament, and any time after the expiration of 4.5 years since the first meeting of Parliament. The amendment removes the provision in the Constitution which permitted the government to pass legislation as urgent bills. The 19th Amendment increases from 7 days to 14 days the period of time a bill is to be made public before it can be placed on the order paper of Parliament. The 19th Amendment also introduced the right to access information as provided by law.
Well, I believe the first of the amendments that we saw right there, the dissolution of Parliament, was quite broadly discussed 2018 when President Maithripala Sirisena kicked out his cabinet and dissolved Parliament. So I think people are quite well aware of the arguments to and for against that. Let's speak a bit about some of the provisions in the 19th Amendment that has drawn praise, actually, from both sides, which is the right to information, for example. But before we get into the right to information, there is one more, the urgent bills provision. Now, although the general public, this might not really directly, at least, affect the general public too much, there is importance here. Could you please explain to us how that works?
Yeah. So now, in Sri Lanka, we don't have what is known as judicial review of legislation or post-enactment review. That is, once a bill becomes law, in some countries, the Supreme Court or the Constitutional Court in the country can say, look, such and such provisions violate the Constitution. Therefore, even though Parliament passed this, it's not valid. We don't have that.
For example, in the United Kingdom.
In the United States.
States, okay.
And South Africa. You have those provisions. Now, here you have a limited window. Within 1 week of placing the bill on the order paper of Parliament, someone can challenge it before it becomes a law. So you have a very limited window. In those circumstances especially, this urgent bill provision was a problem, because you can have an urgent bill and then you negate that time period that the citizen has to challenge it also.
The 18th was brought as an urgent
bill. The 18th was brought as an urgent bill, and then it's referred to the Supreme Court.
24 hours to 72 hours.
Yes, and the Supreme Court can give, but the right of the citizen to go before court is then compromised. And in our experience, urgent bills have not been really used for anything urgent. What was urgent about the 18th Amendment, for example? So it is used for political expediency. So because of that, especially given the absence of post-enactment review, judicial review of legislation, there was an agreement to remove this urgent bill provision. The 7 days been widened to 14 days, that is, you gazette it and keep it on in the gazette for at least 14 days before bringing it to Parliament, is because then the citizens, at least they can access the gazette for that 14-day period, plus the 1 week period when it's on the order paper. So you have more time to study draft legislation. And the possibility of challenges there, because then you have only that 3 weeks in which you can participate in the lawmaking process.
And then after the 3 weeks, after it's passed, like it or not, you will be bound by it.
You will be bound by it. So that's the reason why the urgent bill provision was repealed.
And there has been, like I said before, bipartisan praise of the right to information. and Minister Mahinda Amaravira spoke regarding the constitutional changes that they are planning on making, and this is what he had to say.
19වෙනි සංශෝධනයේ තියෙන ගුණාත්මක දේවල් ටිකක් තියෙනනේ අපි කිව්වොත් තොරතුරු දැරගැනීමේ පනත ඒ වගේ දේවල් ඔය මාධ්‍ය වේදීන්ට අනුගත වෙච්ච ඒ වගේ ප්‍රජාතන්ත්‍රවාදයේ වෙනුවෙන් තියෙන දේවල් බොහොමයක් එකතු කරනවා ඒ වගේම එහි තිබෙන අනිකුත් ගැටලු සහගතකාරී දේවල් ඉවත් කළා තමයි 20 වෙනි සංශෝධනය හදන්නේ අදට ගැලපෙන විදියට වගන්ති කීපයක් ලොකු ප්‍රමාණයක් සංශෝධනයක් වෙන්නේ නැහැ.
Well, we have one section saying that it's going to be a complete overhaul, and like you saw, another section saying that it's just going to be a few changes, a few twerks here and there. Because, well, at the end of the day, we need to accept the fact that the 19th Amendment isn't perfect in all its entirety.
Well, from what's been said, it's really hard to imagine what's going to come. So I think once you see what comes, we'll have to test the drafts or the proposals against the principles of democracy and constitutionalism that we value. And then decide whether some of those require to be challenged in the Supreme Court, if some of those should not be allowed to be passed without a referendum as well. And the public will also have to decide. This is a matter which, as someone said before, there will be debate in the weeks ahead. It's a debate in which the public should engage, because at the end of the day, all of these things, like it or not, directly or indirectly, are going to affect all citizens in this country.
And one final question to you, because we've really reached the end of our show and we're really stretching the time limit here. But there has also been proposals of bringing an entirely new constitution. Now, we've been saddling our initial 78 constitution with so many amendments. I mean, we've come to 1920 now. The government really says that we are bringing this 20th Amendment, but our real goal is to change the entire constitution. So my question to you is, in your perspective, why do you think there's a hurry to get the 20th through? Why can't we just directly go and change the entire constitution after having broad public debate?
Ideally, there should be public debate. During the previous government, there was a consultation process where a consultation task force consulted the public.
This is for the 19th Amendment, you mean?
No, for the new constitution, which was supposed to be
when Parliament was converted into a constitutional
That's right.
assembly.
And before, there was a parallel process with the Public Representations Committee or something, which went out into the districts and sought views. And if you want to change the constitution, you should certainly seek views. Now, we've got views, but if you want to bring a constitution which has values other than the ones that the public told you want a few years ago, then I think you need to engage with the public.
So what really happened to those views that were collected? I'm sure the government spent a substantial sum of money to conduct these consultations. Are they completely done away with? Do they still remain relevant?
I believe they remain relevant. And work was done in formulating principles on what a new constitution should include. And I think those should be built on. But from going by what is said in the media by some of the politicians in the ruling party, it appears that the constitution they envisage is something entirely different to that. And before that type of project is, or that type of journey is embarked on, I think because the constitution is a people's document, it's the people's constitution. It's not a top-down thing. It's supposed to be something which the people want. And I think you need to engage in that type of a consultative process first. And I also don't see the grave urgency to rush through this. And you ask the question, why? Perhaps because they feel that, it's you barely made a 2/3 majority. It's a put together type of majority. And there might be different views even within that coalition as to what you should and should not do.
You think 145 seats is a barely put together majority?
No, I'm saying the 150 that they require is put together. But within that 145, I think I read somewhere that the SLFP said they are going to put together the committee to study constitutional proposals. So there might be different views within that group as well on what amendments should and should not be enacted.
Right. So all of these discussions really before the 20th is presented is obviously speculation as to what the 20th can be. But today's discussion was mainly focused on the provisions of the 19th Amendment and the merits and the demerits of it. And we've really reached the end of our show. Thank you very much, Attorney Att-at-Law Suren Fernando, for joining us on our show to discuss the substance of these legal provisions. Of course, As we go along on our show, we will continue to bring you more details about the law that governs you here in Sri Lanka, because as time and time again it has been proven, it is important that the general public have an understanding regarding these provisions that govern you, because at the end of the day, these laws are made for the public by the representatives that they have chosen into Parliament, and public knowledge, the public knowledge about these laws is quite important. Thank you very much to all our viewers out there too for tuning in. Until next time, take care and God bless.